Great, thanks. So thank you for inviting me to talk to you about race in the German Legal Academy. I have a slideshow, so I'll put up some slides, but the format of this is I'll just speak for probably 35 minutes or so, and then I'll kind of end the presentation with a set of questions that I think we'll be able to all think about and contribute to. You can also ask your own questions, but the questions that I have are more to get people involved in thinking about how the question of the treatment of race in the German Legal Academy affects their own work. So where are you positioned? How are you engaging with these concepts? Where do you feel like you're being challenged? Where are there obstacles and where are there opportunities? So, so that's kind of the format, and so I'll begin that in a moment. But also, by way of introduction, I should make clear a few things. First of all, I have studied law, and I am a qualified lawyer in the U.S., and I teach law here at Birkbeck in London. I was involved in legal research in Germany, but my PhD and my graduate studies in Germany were actually in the discipline of anthropology. So while I do know about German legal academia, and while I have lots that I think, lots to offer in terms of questions that might provoke you to think critically about your own place in German legal academia, I'm not formally a German legal academic. That has its pros and cons, I think, for this conversation. So that's just something to keep in mind for opening the conversation. So just a little bit about me. I started my studies in anthropology in the US. I did my undergraduate in the US. Then I went on to do a master's at Humboldt in Berlin in Europäische Ethnologie, which is European ethnology, which is more or less social anthropology. Then I went to New York and London to do my JD and my LLM. So that's where I got my legal training. And then I returned to Humboldt University to do my PhD, which was on legal activism. So basically anti-racist activism through legal processes. So I looked in depth at the Uri Jallo case, and I also tried to construct the kind of a broader context for doing anti-racism work as activists engaging with legal structures. So that was how I paired anthropology and law in my research at Humboldt. So I'll be kind of bringing that into it a little bit. So now I've been at Birkbeck at the University of London in the law faculty for 12 years. I'm the dean of the faculty at the moment, and it's a lot of administrative management work. So there's a little bit of my reflection that will also have to do with raising questions around how structures in universities also are a part of the conversation of race in legal academia. So let me open up the slideshow. So by way of introduction, this picture that you see of lots and lots of, I guess, men in wigs, white German men in wigs, is from an actual classroom in a philosophy department in Gießen, where the philosophy department cleverly hosted a conversation on race and philosophy in Gießen. It was expertly chosen, this room, but we talked about the space so much that it became a real, not just a tangential conversation, but a real conversation about what it means to have university spaces be open for conversations on race, but also in terms of representation and what it feeds back to the constituency of the university. So being in this space set the tone for a certain type of conversation. And I chose this image because I think legal academia, not only in Germany, but definitely in Germany, is seen to be a space where one has to fight to be included, and where conversations are already closed to certain avenues of analysis. So it's just something to kind of set the tone and to think about. So some of the aims for this talk and the kind of questions that follow are to frame certain challenges and opportunities around German legal academia and conversations on race, and to generate reflection and discussion on potential projects or whatever work that you're engaged in and ways to get support for them. So you should probably bear in mind what you want to actually get out of this workshop. I framed it as a workshop because I think it really is open to all of us what we want to take from it and how we want the conversation after the presentation to evolve. So just think about what you want to get out of it and what brought you to the session. If it wasn't so obvious because of the work that you do or the experiences that you're having in German legal academia, what interests you about this conversation that you'd like to explore? So first, I think I left a slide out, but I'll be talking about 4 different questions. The first question, or the first topic, is race as a legal concept. And this is something that it's hard to do a comprehensive, give a comprehensive treatment of Germany's legal construct of race. But just a couple of things that you might be aware of and a couple of things that frame, I think, some of the more nuanced debates around race are the way that it operates as a legal category. So I've put France and Germany here as comparisons because it's hard to talk about the German treatment of race in a vacuum. It's interesting to think about how race is treated across Europe and to reflect on Germany's treatment of race in that context, because it gives a little bit more depth to the position of race in society. So France has a comparatively strict treatment of race in terms of outlawing the way that it's used in certain contexts. So race as a category is prohibited, which means you can't collect data on the basis of race, except in very narrow circumstances. Racial categorization is itself a criminal offense, which means if you're being discriminated against at work, you raise a criminal claim with the Ministry of Labor rather than raising kind of a civil claim against the employer. And the word race has recently been removed from the French Constitution. So part of the reasoning is that race doesn't exist, so we shouldn't perpetuate the use of the term. But this is widely, I think, perhaps widely in the circles that I'm used to discussing race in, but also in other parts of Europe, it's regarded as a bit of a too easy response. To outlaw race is not necessarily to get rid of racism. So how do we think about outlawing the category of race as a way of dealing with racism? But that is the French model of the treatment of race as a legal category. Germany has a model that's kind of in between the French model and something like a UK model, where in the UK, race is very present as a legal category. There's lots of litigation in terms of racial discrimination. It's been a legal category for decades, and it's seen as a valid way of understanding social stratification. In Germany, there is kind of a partial acceptance of the concept of race in terms of describing people's experience, but most of the time, in most contexts, there's a preference for uses of other categories that are similar to race in some way, or proxies, used as proxies for race. And I'm not saying necessarily that these are efficient or adequate proxies, but they're used as proxies in certain social policy contexts. So concepts like migration background, so Migrationshintergrund, so we've heard that before, or the language that's spoken at home, or the birthplace of parents, or ethnic origins. So all of these concepts in certain contexts, let's think about the educational context, or in terms of representation in a certain labor market. Those might be used as proxies for a certain type of diversity or representation that race would maybe in another context be used to describe. But then the question is, are these proxies adequate for describing race and racialization and discrimination in all of those different contexts. And I think, you know, as an anthropologist myself, I would say that these are different categories that do different types of work. So that's one thing to keep in mind. Also the German word Rasse is a very controversial word in Germany. So anyone living in Germany who's dealing with race and the law will know that Rasse is very different from the English word race. So there's a linguistic difference. There's a difference in terms of historical context and the connotation of using the word Rasse. And there's a difference in the sense about what it means when you put it in a legal context. So that's why my third little point here, it's been debated as to whether Rasse should be removed from the constitutional equal protection clause or whether it should remain. So I'll get to that in a moment, but this is a question about how we can even talk about race in a legal context in Germany. So the big question I put here is, how does limiting the language or concepts available for expressing racism in the law perpetuate or exacerbate institutionally racist practices? So language does matter. And this debate about how we should talk about or frame race is a really important one to consider. So you might not have an answer, but it's important to consider in the context of the legal concept. And then in the wider context of Europe, there's a general, there's a general lack of data that shows patterns of racism because race is treated differently in different places. And in a lot of places, there's what I've described in the third paragraph as a prohibition with exceptions. So there's generally an understanding that race isn't going to be used except for in certain circumstances in terms of collecting data. And that's been documented by the Council of Europe reports. And there are different reasons why this is the case in different European countries. But what it means is that it's sometimes difficult to identify patterns of treatment of racialized communities. And that is a problem for articulating how racism affects certain communities in Europe. So it's not a judgmental question about whether we should use race or not in all circumstances, but the lack of data does make it hard to identify patterns. And then just to kind of round out the discussion of race and the law, of course, race is in the constitutional protection of equal treatment. So that's Article 3, Paragraph 3 of the Grundgesetz. It's also in the German anti-discrimination law, so the AGG, as a provision of that protects people from racial discrimination. So race exists in law in those two ways, as Rasse, aufgrund der Rasse. And there has been academic debate as to whether that should be replaced by racist discrimination. And on both sides of the debate, there are some interesting points. I mean, on one side of the debate is a question about whether Rasse as a term should be used by the government at all, and whether there's a trust for that, and whether it adds anything to have the noun, Rasse, rather than to replace it with an adjective that demonstrates through the grammar that it's actually something that people are doing, like it's an action based on some faulty logic, rather than a noun that actually exists. Whereas on the other hand, the scholars I put at the bottom here, Cengiz Barkışkamaz and Nahed Samor, have written really, I think, a really erudite, clear opinion piece about how taking away the noun actually might not help matters. It might actually hurt the ability to have conversations across borders about race, because taking away the noun just makes the language around race and racism more difficult for lawyers to engage with, not less difficult. And that's maybe a technical reason, but it actually might have real impacts on how we then use the law as a tool. So I think it's an important debate to take part in, and it's not necessarily the same kind of debate as just thinking on the surface, oh, I don't like that word, we should get rid of it. There's a legal technical aspect to the debate. So that's my first question. So not question, kind of area to explore is race as a legal concept, which is bound to shape how lawyers working on the legal category of race will have to encounter it in legal academia and what debates to be aware of. The second big area, and this is where the questions start to appear on the bottom of the slides, is race as a category of analysis, which isn't necessarily just how the law defines race, but how we use race to explain social phenomena. So a couple of things that I've come across in doing work on race in Germany, whether as a lawyer or as an anthropologist, is race is an American thing. So it's an American obsession. Americans are like pushing this race agenda. And now, like, you know, that concept has been around for quite a long time, but now we're hearing new language for it, you know, everyone's woke, we shouldn't be so woke, and all the kind of things that people say, but basically displacing race to outside of the borders of Germany or outside of Europe. The second is race is an obsolete term. This is a bit more nuanced than just, so it doesn't exist here, but more like we can express race through other concepts, and this is the proxy concepts that I mentioned, without all the harms that using the concept of race produces. So if we can use ethnicity or use these other concepts, we don't have to use race, and then we avoid lots of problems. So that's another thing that you'll encounter. The third is that it's more about culture or ethnicity. And this turns it into a question of, you know, integration and culture rather than about racism. So it displaces the issue onto communities and their difference, rather than looking at how racism exists and how race is imputed onto people, and then there's racism. So it's a slight shift in kind of the focus of the conversation. And then another aspect that you'll definitely hear in legal contexts is critical race theory is political or ideological, and it doesn't contribute meaningfully to legal analysis. So that's a very specific way of saying something like, when you talk about race, you're not really being rigorous, or you're not being theoretically complete. And that comes up a lot whenever you know, in various other disciplines as well. If you're writing about race, you're writing about experience, or you're writing about something that isn't really rigorous. That is easily rebutted in most contexts, but then there is a strand of thinking about race as valuing the experiences that people have in a context where, like I said, the language might not support or the data might not be available to make claims that we experience. And those things are important to be able to have, you know, you need the vocabulary and you need a lot of confidence to still make claims in a legal context where the law and the legal academia is very wedded to a certain type of evidence and a certain type of theoretical approach. So all of those things then lead to the conclusion within certain frames of legal analysis that race shouldn't be used as a lens of analysis. So it then puts even more, or it raises the hurdle even more for those who see a certain issue and want to explore the racism in a certain issue, or the element of racialization of communities and different treatment in a certain issue on the basis of race, because there are all these other you know, ideas within the discipline that prevent that from being taken seriously. So just a couple of thoughts on this. There are different ways to define race and racism, of course. One way, and the interdisciplinary, the idea of interdisciplinary approaches to legal studies is a recurring theme in what I'll be talking about. One way to define racism comes from Ruthie Wilson Gilmore that you might have read before. Racism is a state-sanctioned and/or extra-legal production and exploitation of group-differentiated vulnerability to premature death. So this type of defining racism, not just, an employer treats one person different because they have an explicitly racist worldview, which individualizes the issue and makes it an issue of preference. This definition steps back and understands the way that racism operates to be dependent on a certain type of state-sanctioned or extra-legal exploitation of vulnerability to death. So that's this seems like a long chain, but that enables us to see health disparities or migration status or working conditions as a form of, if it's differentiated by groups, as a form of racism that's produced and that is supported in social structures. So it doesn't need to necessarily say here institutional or structural racism, but Gilmore is saying this is a framework for understanding racism more generally. And I think if that's the framework, then we are thinking about very broad social issues that can be explored using this as a lens. So, of course, how we use race as a lens will depend on the definition we give it. And this is one, I think, expansive definition that helps us to make use of race as a lens. The other one comes from a narrower place, I think, but one that is well established, at least in the United Kingdom, in terms of the vocabulary around racism, and that's institutional racism. And this is from the 1999 McPherson report. The McPherson report was written after a young man named Stephen Lawrence was beat to death by 4 young white men. So Stephen Lawrence was a young black man. But what happened was the police didn't actually investigate this properly, and they started blaming, the community for this, kind of following up with members of the community, the Black community, more than they would have gone after the young white men who beat him up, and it led to this investigation because how could it be that this happened and the police were treating the family and friends in this other way and not actually getting to the bottom of how he was killed. And so the definition was that there was a collective failure of an organization to provide an appropriate and professional service to people because of their color, cultural, or ethnic origin. It can be seen or detected in the processes, attitudes, and behavior which amount to discrimination through unwitting prejudice, ignorance, thoughtlessness, and racial stereotyping. So this at least articulated the idea that an institution could have a posture. So it wasn't just individuals who are bad apples doing bad things. It was that a collective failure was possible on the part of an institution that supported processes and behaviors that could have even meant that people were unwittingly inflicting harm or underserving certain communities. But that was still a part of what it meant that institutional racism existed. So the unwitting prejudice, ignorance, or thoughtlessness is an important feature of that definition. This definition in the UK, I think people look at it quite cynically now, because since this report was written over 20 years ago, there haven't been enormous strides in policing, or at least most academics seem to think that there haven't been really a lot of improvements, partly because a lot of the recommendations that came out of this report either weren't followed up or weren't implemented properly, and it didn't cause a mindset shift But in terms of being able to articulate what racism is, it is a useful way to at least, manage a little bit of the individualization of racism that exists in a lot of popular understandings of racism. So I just want to go through maybe one or two, I'm not going to go through all these slides, but one or two examples of issues that come up that aren't necessarily articulated as racial issues in legal terms, but lots of legal scholarship is using race as a lens for understanding what's happening. And I think that's one challenge maybe in a lot of continental European legal departments, law departments, because the room for interdisciplinary analysis around how certain social phenomenon are also racial phenomenon. That might be more restricted, let's say in Germany, in a law school in Germany, than it might be in a law school in the UK. So one is the one is people on the move. So refugees, for example, and the intersection of migration with human rights. So one case is the case of pushbacks, as I put here on the side. They're seen by the European Court of Human Rights as a potential violation of Article 3, which is the right to be treated humanely, so freedom from torture, basically. And in that case, the Hirsi case, it was where Italian authorities should have known that return to Libya of the people who were crossing the Mediterranean would expose them to arbitrary treatment and potential return to their countries of origin where they could be tortured or killed. So one question is, how do we think about the treatment of those moving across the Mediterranean as having systemic or systematic negative impacts on racialized minorities? A similar question has come up in the context of the UK, where if you've been following UK politics, the Home Office has instituted a policy of sending certain male applicant men who are applying for asylum who've arrived in the UK by boat to Rwanda to be processed, have their asylum claims processed. Whereas if they're coming by other means, might have the privilege to cross and by other means, are not. And that is potentially going to, well, it's quite almost certainly going to impact certain racialized communities more than others. So what do we think about that, and how do we articulate racialized the racially disproportionate impact as a form of racism? And this relates also to equality law. I mean, if we think of direct discrimination in equality law, is basically if someone's treated poorly because of who they are compared to, someone who doesn't share that characteristic. Whereas indirect discrimination is about looking at the impact, basically, of a certain neutral policy, neutral in the sense that it's not directly related to race or any other protected characteristic, but it has an impact on certain communities disproportionately, like a policy of returning people only if they came by boat trying to get into the country, which will almost definitely have a disproportionate impact on certain communities. So being able to articulate these things as a form of racism, or at least having a lens of analysis that looks at racism in the policy, is useful in a legal faculty. Another example is these crimes of solidarity. So one example from the German context, well, at least I guess the protagonist is German, was Pia Klemm, who was a part of an organization that was basically helping people in distressed boats who were crossing the Mediterranean, so that they wouldn't perished because the boats were potentially in distress or sinking or whatever. And she was fined and faced imprisonment because of a law, an Italian law, about aiding and abetting illegal entry that was based on the idea that you were then helping people smugglers. But the alternative is potential non-intervention and the potential that people die on boats, and who's dying on boats, and what, how do we think of the racial implications of this law versus the idea that countries should have some control over their borders and the water. So human rights, race and racism, and immigration are all tied together in these crimes of solidarity. Another example, the Hungarian law about people crossing into Hungary, and anyone helping them would be prosecuted and potentially jailed. So it goes even farther, it goes just as far, I suppose, as the Italian law. And it's about keeping certain people out and certain people in, and controlling how the public engages with that. So I think those are all areas that we can think about in terms of a racial lens. And maybe a broader question is one I put at the bottom: how do we think about the relationship between racism and nationalism in these contexts, particularly now? I mean, I think since 2018 and 2019, things have only gotten sharper in that context. You only have to look at the conversations around the treatment of people escaping Ukraine and the racialization of those different communities escaping Ukraine to know that that's an issue. And to take one step further, although a couple of years prior, is the very highly racialized language of right-wing politics. And so Germany, I think, is one example where it's hard to deny that race in the political campaigns of the Alternative for Germany, for example, was not necessarily being used kind of as the social construct of race. There was a return to a biological idea of race, precisely the type that I think most commentators on the debate of the constitutional, the inclusion of Rasse in the Constitution assumed was completely gone. And so that's why we don't need the term Rasse. But actually, if we look a little farther into how politics is organized around the question of race, we see that some of it is actually the old school biological racism. So this poster, new Germans will make them ourselves, and a picture of what seems to be demonstratively white women laying on a, in a field on a blanket or something, is quite jarring, because it is really a call to kind of eugenic type of social like way of organizing society that is dependent on us understanding the cues for race. So I think it's important to think about the potential for biological racism to go unnoticed if we scale back the language around which we can analyze these types of maneuvers. And I guess the last German example I'll give you is the Urigello case. I don't know if people know about the Urigello case in a lot of detail, but Urigello was a man who was originally from Sierra Leone and who died in a German jail cell in 2005. And a lot of the discussion around how he died has been, mired in this the question of whether police are obfuscating the ability to figure out the details of his death, either by not participating in the trial or for telling stories that are contradictory, and for the prosecutorial service not going farther and trying to raise a question about whether anyone was involved in his death, rather than assuming that he killed himself. So it played on this idea that that someone applying for asylum would, out of some sort of desperation, kill themselves in a cell as a way to deflect the possibility from the police. So that wasn't a line of, I mean, don't get me wrong, that wasn't an explicit line of reasoning in why the prosecutor didn't go for these charges. But just stepping back from it, I think the way that the public has understood this case and those who haven't questioned why he would do this to himself in such a brutal manner probably rely on this idea that there's a certain type of person who will do this kind of thing, and this person fits the profile because potentially of where they're from and the circumstances that they're in, rather than to kind of understand the vulnerability that someone in his situation, both in terms of racial background, but in terms also of migration status, the vulnerability that they would have faced in that situation. And indeed, because it's hard to then dig further into the case, it shows that there's also a certain question to answer for legal structures. So why has it been so difficult to make advancements on a case where so much has gone wrong? I can talk about that forever, but I don't want to spend a lot of time on that. But in the Urigello case, one of the questions is how to talk about race and racism in a case where there's been no explicit kind of line of questioning in the legal case about whether this was racially motivated, although it seems to haunt the legal case in lots of ways. And there hasn't been kind of, a very clear issue that was raised in terms of the police testimony that would have demonstrated a clear racial motive. So there were racial comments that were made, but it does leave a question of how to grapple with this concept of race for something that's happened to this person, other than to just say, would this have happened to a white German person? Potentially a person who was vulnerable in very similar ways, potentially. But it does raise the question of how to talk about race in death in custody cases. It is possible to talk about race, but that's a challenge that I think legal scholars have, to be able to articulate things that they then need to draw from other arenas of analysis, including other disciplines, to talk about. Okay, I'm going to skip some of these, but I will talk for 1 minute on this thing in the United Kingdom, just as a point of reference. The hostile environment policy. So 10 years ago already, there was a committee in Parliament set up, which apparently had the name the Hostile Environment Committee or something like this, which was then changed to the Compliant Environment, and the policy that came out of that was the Compliant Environment Policy. But it was basically a policy to make it difficult for those who didn't have valid immigration paperwork to live and survive in the United Kingdom by linking up the different processes. So, the little different services that people needed to engage with in order to live. So with employers, landlords, hospitals, and schools, with reporting requirements to the Home Office, which meant that landlords would then need to get a copy of the people's passport that are renting from them in case the Home Office ever checks. And the landlords would be fined if they didn't, which on its surface sounds like a bit of outsourcing the work of the Home Office to private citizens, which it was. And on another level, the UN Special Rapporteur pointed out when she visited, Rapporteur on Racism, pointed out that this actually then changed the behavior of service providers who no longer wanted to take risks in making mistakes, and they just simply started to treat people who looked like they were not from the UK differently. So it led to more discrimination in housing, more discrimination in employment. So those types of things, and more people who didn't want to go to hospitals for fear of being reported to the Home Office. So more people not taking up certain services. So this basically had a really harmful effect on communities of color, regardless of immigration status, but also on those communities of color who didn't have valid paperwork. So that's a way of thinking about a policy that is framed in legal terms around immigration status, so nationality, passports, documents, thinking about that in terms of its impact on communities of color, and the way to think about that as a policy that is highly racialized. So I think those are the types of challenges that I think exist in legal academia for being able to articulate these issues. I'm almost done, actually. So the third broad question is race and higher education structures. This is a really short part. And the question that comes out of that is, where is your work located? And where's the type of work that you want to do on race or racism or social justice located within higher education structures? So I've just broken it down into teaching, research, and administrative management structures, partly because those are the structures I'm really familiar with, but also I think that encapsulates a broad range of different angles of how German legal academia affects your life if you're in it. So teaching, and this can be from the perspective of a teacher or student, there are at least three things. There are tons more probably, but at least three things that I think about when I think about race and how it's implicated in these structures. One is pedagogical approaches. That can include access to education, thinking about a diverse range of students. Some students, and I teach at Birkbeck, and we teach to students, including those who are returning to education after a long period of time. So access to education and prior educational experience. Some students might have had the privilege of growing up with parents who went to university, others may not have. This also in some places has disproportionately affects people on the grounds of race. So how do we think about addressing access? Student engagement, that picture I showed in the beginning, with all the white men on the walls, and the question of who feels safe in what context, who feels like they can speak, who feels supported. Those questions also speak to the question of race in higher education, and how students perform in class and how they engage also is related to that. Curriculum. So of course, we've all heard about decolonizing the curriculum and the question of what's on the syllabus, who's on the syllabus, how we're using different literature, whether we're looking at a broad range of ideas. Those types of questions come up in curriculum design and how students experience curriculum. And interdisciplinarity. So in a law faculty, and particularly I think in continental European countries, so Germany, for example, looking at writings from other disciplines, I think is sometimes very challenging within German legal education. And so lots of colleagues tell me this, and I know for a fact, that it's not only in Germany, but the law tends to look inward at, cases, how they're decided, thinking about jurisprudence and thinking about the logic of judicial decision-making first, and then anything else is kind of a bonus, or maybe even a tangent, or maybe an extravagance, maybe not something that's necessary. Whereas for some questions, and I think race and social justice are among those questions, looking at other disciplines with at least just as much weight as the legal rationales. So looking at social science, looking at sometimes literature, looking at philosophy, can be as important as looking at what the law is saying on certain issues, because sometimes the law lags way behind social thought and other types of scholarship. So being able to use other scholarship from other disciplines in a way that helps illuminate something about law, I think is one of the challenges that we have. And then classroom dynamics. So the dynamic between professor and student in the very hierarchical university setting in some places can be a really important one to address and be cognizant of. Being able to take on board as a teacher in German legal academia, be able to take on board questions that come from students based on things that they might not have thought of before. And looking also at the power dynamic between students and in terms of intersectional forms of experience. So gender and race, or ability and race, and how that impacts the experience in the classroom. Diversity and representation and language are also other aspects that inform the classroom dynamic. So this is about thinking about how your work and how your engagement with academia might also speak to some of these issues. Research. Some of the things here are about, you know, if you have a project you're working on, maybe these are important questions for you to think about. The evaluation of the content of the project. So how is critical scholarship on race valued or positioned? Is it valued within your discipline? Are there things you can do to open a conversation that might seem like a closed door? Are there approaches you can take to making your scholarship speak to questions that will help people to open their minds to it, but not to change the essential point that you're making? So how do you deal with critical scholarship on race maybe being undervalued? What counts as theoretical work? I think I've mentioned this before. And what counts as legal research? And that's something that I think law faculties in Germany, but also in lots of other places, are sometimes a bit intransigent about. So this isn't legal enough because it's not doctrinal. It's not speaking to a certain judicial outcome or policy position. So those types of questions I think are important ones to be aware of. The support for innovation. And innovation, I also mean creativity and interdisciplinarity. So it links back to the point I made in teaching. What kind of support is there? So is it funding? Is it research mentorship, PhD and postdoc places, research that leads to a career? How do we think about the place of research on race and social justice issues as leading to some, as being supported and then leading to some life beyond in German legal academia? And then publication requirements. And that's maybe more of a specific thing for once a person is in a postdoc or in an established position, but what publications count and what don't count? What kind of value system is set up for the type and style of publication? So, and where you place it, how all of these things relate to your ability to then be valued, credited, and then hired, I think are all really important parts of regarding the place of race in research in legal academia. And then administrative management structures. I think all of these things relate: teaching, research, and management structures, including hiring and promotion, all relate to one another. But once you get to the technical details of hiring and promotion, and this is maybe something that institutions need to think more about, and that those of us in institutions can think about our role in questioning current practices, do conventional value systems for certain types of scholarly work disadvantage scholars working on race and social justice in particular ways? So again, that's about where they're publishing, how they're publishing, what they're writing about, the interdisciplinarity, that type of thing. Because, and this is the second point there, that a lot of scholars working in or studying in Germany end up doing brilliant work and then leaving Germany. I mean, I don't know if those on the call have noticed that, but some brilliant critical scholarship is being done by Germans or people who have studied in Germany and have chosen to leave or have not found a place in Germany to produce that type of work that's now been then acclaimed in other parts of the world, even when they're writing about Germany. So it's not that they're writing about some American fascination with race and they're located in Canada. They're writing about Germany and race and maybe Europe and race, and they're located outside of Germany. So that's something to consider, and it's something I think that German academia generally has to consider, but German legal academia needs to consider quite, desperately. And then things like funding criteria and mentoring policies, I think, all impact how critical scholarship on race is supported in academia. And then the fourth is just this one slide, and then I'll turn it over to you with wrapping up with these questions. Or what are your own experiences navigating legal academia in Germany, in particular experiences with racism? So it's not that they need to be, it's not that these experiences are necessarily dramatic, but where have you noticed certain aspects of your experience having been shaped by a question that's come up in this presentation already? So it might be a lack of support in a certain area or a certain pressure to do a certain type of work. Of course, that's very different from being kind of racially harassed, right? But it's still a part of how we can think about the embeddedness of certain presumptions in legal academic structures that then impact your choices and your ability to pursue certain lines of scholarly research that then might prevent innovative scholarship on race and racism. I mean, that's a certain way of protecting and gatekeeping knowledge, which I think maybe in a very academic way, but that is a form of racism. So it's useful to think about how our own experiences have been informed by the existence of race in these structures of legal academia, learning from them, and then seeking mentorship and maybe building by being a mentor with others who might experience these things in the academic community. So I think that's kind of a cycle that we're all, I think, maybe a part of just by virtue of the things that we're working on. But that is maybe one question of, how can we use community and networking and building together as a form of strength within these academic structures. So that's it. Those are the 4 questions that I wanted to raise. What are the issues surrounding race as a legal concept? How do we talk about complex social problems using race as a category of analysis? Where is your work located institutionally in higher education in German legal academia? And what are your experiences of racism in higher education that might help you to build with a community and at some point serve as a mentor, if you're not already, to those who are starting out? So that's where I wanted to kind of leave it, and then open it up to those of you on the call to answer those questions, offer reflections, maybe critique something that I've said. Yeah, so it's over to you.